One of the things about our show is it's going to be unique.
You are what you do. You can say any amount of things that you want to say, but what you do is what everybody sees.
People are like, oh, I'm just going to JV it. Like, it's just JV it. Like, what the hell does that mean?
I cannot tell you how excited I am to hang out with you guys today, so thank you so much.
Well, then that end buyer could come back and say, well, I didn't fully understand that it was subject to.
That's not a thing. Like, the SEC has thought of all of these things. They've been here since 1932.
And you can do what you want with your property.
Buyers have time, they have negotiating power, they have options.
Oh my gosh, I am blown away by your inexperience, and they've been in business 20 years.
And that includes things other people put on your property, right? It's your property to be okay. Suddenly, cousin Jimmy's in a lawsuit.
A novation is replacing one contract or one obligation with another.
Out with the old, in with the new.
Yes.
Hey, good morning, everybody, and welcome to the show. Today, our topic is the top 5 asset planning strategies for 2025. I'm Andy Fowler, and I'm here with Sean St. Clair. If you're new to the show, we've been doing this for a couple of years. You know what to do. You need to like and subscribe. You can find us on X, Facebook, and YouTube, and you can find us at the handle at INREM Podcast. That's at INREM Podcast. Go there, subscribe on our YouTube channel, like it, helps us out a ton. Also, if you're not into watching a podcast, but you'd rather listen, you can do that. And you can download our podcast either through the Apple Podcast, or Spotify, or any of the other major podcast platforms. Go there, download it, like it, leave us a review, helps us out a ton. We appreciate it. With that, we're going to go to Sean, who has our legal update.
Thank you, Andy. So my legal update today is kind of a year-end planning strategy for real estate investors. And what I recommend is reviewing and updating your purchase contracts and other documents that you use for your real estate transactions. And in particular, review them on a state-by-state basis. And so what I mean by that is, and this doesn't hold true for every piece of legislation or for every state, but a lot of times during the year, legislatures and governors, legislatures pass and governors sign into law legislation that generally will be effective as of January 1 the following year. So they, come up with these new laws and regulations, and then they go into effect January 1 of the following year. So if you're a real estate investor out there and you have purchase contracts that you like to use in the various states, I encourage you to reach out to attorneys in each state that you're looking to transact in 2025, and have them review your purchase contract or any other document that you're using for purposes of acquiring or selling real estate, to make sure that they are going to work in 2025, that there's no changes to the laws that are going to require maybe additional language, require additional disclosures, impact your business come 2025, and just make sure that you're good to go going forward. It's actually even if there's no law changes, it's actually good to have another review, another set of eyes on your documents to make sure that, hey, there's nothing in here that's going to trip you up in whatever state you're looking to transact business. Maybe you are working in certain states and you decide, oh, I think I'm going to branch out or venture out next year to another state. Well, this is a perfect time to basically reach out to an attorney in that state or states that you're looking to branch out to, and have them make sure that your purchase contracts and documents are prepared and meet the laws of those states, and make sure you're not going to end up in hot water because you don't have certain disclosures, language, or maybe you have terms in there that aren't allowed by the laws of those states. So this is a good time to kind of do some year-end New Year planning, and so I'd encourage you to review and have your purchase contracts and other documents updated.
All right. Thank you, Sean, for the legal update. With that, a couple of announcements. Next week, Tuesday of next week, which is a big day for the Interim Podcast. Every Tuesday is our show in the Creative Finance Collective. But next week, as many of you know and have been planning for, is Christmas Eve. So we will not be having a show on Christmas Eve. We will not be having the Creative Finance Collective on Christmas Eve. I know you're disappointed. I know you had planned to spend your Christmas Eve watching, but alas, we will not be there. So we will plan on seeing you in 2 weeks from today. However, today is Tuesday, which means we have the Creative Finance Collective this afternoon at 3:00 p.m. Arizona time. What is the collective? If you're just now learning about it, it is a live stream get together of attorneys in the space of creative finance, and we get together and talk about creative finance. But what we do is we're there captive to you, the listeners. So we're taking questions for up to an hour or until we stop getting questions. If you have questions about creative finance, how it works, problems that you've seen, and want to know the inner workings on how you might get involved or understand this from kind of the legal side of things, or maybe from a different state perspective, as we have members of the collective that attend from different states. Make sure to join us. You can listen to that on Facebook, X, or on YouTube, and that's at the @InRem podcast handle. We're there again, 3 p.m. Arizona time today. Make sure to be there, and we'll answer any questions that you have. Also, we're taking questions with our guest today in the final 15 minutes of the episode. So if you have questions, make sure to post them in the chat. You don't need to wait until the end of the show. You can post them as you think of the question, and we're there to monitor that and ready to go over those questions, as I said, in the final 15 minutes. All right, so today we're going to get into our topic. We're talking about the top 5 asset planning strategies that we think as attorneys you should be thinking about going into 2025. And with us to discuss that is attorney Logan Woodruff. Logan, thanks so much for joining us.
Thanks for having me.
Yeah.
Glad to be here.
Yeah, glad to have you. And if you're a regular watcher of our program, you will note that we've had Logan on before. Is a wealth of knowledge, really good information, and we wanted to make sure to have him with us today to discuss this topic. Now, Logan, for those who aren't familiar with you, or maybe are just being introduced to you for the first time, why don't you give our listeners a little bit of your background, how you got into doing what you do, what you focus on as an attorney, and you know the areas of practice that your firm primarily focuses on.
Yeah, great. So yeah, my background is actually in construction. I did that for a number of years here in Arizona. And then from there went to law school. Post law school, I've been doing mostly estate planning and estate tax planning over the last decade. And that was our last topic of conversation earlier this year, was estate tax planning. We might want to touch on some of those issues that have happened since the election this year. But over the past couple of years, I expanded into asset protection as well, and helping clients not only, and I would say it was more of the missing kind of component of the estate tax planning practice, when clients would come to me with, hey, we want to pass our businesses and real estate and other assets onto our kids. And while they were there, they asked a lot of questions about, hey, how best can we structure our entities? How can we get more privacy? How can we have more protection while we're here? And so I do all of my estate planning and estate tax planning through the Woodruff Law Firm. That's me. And I've got an assistant there in my firm. The asset protection component I do with a friend of mine from law school, John Scablin, and his firm is Scablin PLLC. So that's kind of the background there and how I work with clients.
So Logan, it's not completely off topic, but you've piqued my interest, and we like to stay up to date with the trends in the law. We know that the election has a large impact going forward on what federal law is likely going to look like, and estate planning typically has something to say about that. You just mentioned something we may get into about that. Why don't we just hit on this? What changes or things should we expect to be thinking about from the estate planning side of things, given what happened in November?
Yeah, so with estate taxes mostly, what people were concerned about come 2026 is the loss of the estate tax exemption out. So a little bit of history there. Estate taxes apply when you pass away. People call it the death tax, right? And it only applies once your net worth reaches a certain threshold. That threshold today is quite high, but back in the early 2000s, it used to be, a couple $1 million. 2010, it was unlimited that year. I think I mentioned this last time, but the owner of the Yankees died that year. George Steinbrenner passed the Yankees on to his family, estate tax free. 2012, they passed it with Obama to put the exemption amount at $5 million. It was supposed to go up from there with inflation. In 2017, it was retroactively doubled from 5 to 10 million with inflation. So in 2025, that number is supposed to be 13.99 million. And when they doubled it from 5 to 10, Congress didn't have enough votes to make it permanent. Now, that was the Tax Cuts and Jobs Act. That was one of Trump's babies, if you will, right? And so with him getting back into the White House come next year, most people in the estate tax planning world are thinking that he's going to want to do everything he can to either, extend the sunset of that. So the sunset is supposed to be 2026. It was supposed to go from 10 million back down to 5 million because they didn't have enough votes to make it permanent. So at least in my world, most people are thinking that he's going to have the votes to pass something to either make that doubling permanent or to extend the sunset there.
And it would seem to me, this is obviously just a guess. We don't know how this will play out, but what the administration does from a tax approach is, I think, likely to come up right at the beginning in terms of some of their initial legislation that they pass. So my guess is that what we see happens with regard to the estate tax, the sunsetting issues that are happening with the prior law, really get addressed probably in the first 6 to 8 months of the administration. So it seems to me we're going to know a lot in 2025 about how we're planning in 26.
Right. Yeah. Now, that's the hope that everybody does that. But, if December rolls around, there's probably going to be a lot of people who are trying to do some last minute planning. But yes, much better for everybody if it got done early.
All right. So today our topic is asset planning, as we mentioned. So we want to get into that. We mentioned we're going to talk about kind of the top 5 things we think you should be thinking about going into 2025. But we want to lay some groundwork because I think, as attorneys, we take the term asset planning for granted, and it's a term of art, and we've dealt with it for a long time since law school. But take for granted the fact that a lot of folks don't even know really what we're referring to or why it's even an important thing. So when we say asset planning, what do we mean by that, and what are we usually considering when we enter into that discussion?
So very often I get confused with just a standard estate planning attorney. When I'm talking to people about estate planning, which I do, I'm talking about, hey, how do we pass assets on to our kids? How do we avoid estate taxes? How do we provide them with protections when we're gone and not just, give them a blank check, essentially, right? So when I talk to a client about asset planning, or as I refer to it, asset protection planning, it's more net worth insurance, right? I'm trying to help clients move assets to a safer place. We're going to protect them in the event of a lawsuit, protect what they've built up over their lifetime. So we're not defrauding anyone. We're not having clients make themselves illiquid or insolvent. We're actually telling them, hey, there's a better way to structure your assets so that you've got more peace of mind long term.
When do you think generally somebody should start thinking about that? I know that, the levels of wealth or lack thereof, are exponential. I mean, at what stage do you think it's important, I guess, in terms of net worth, that somebody really begin thinking about doing some thoughtful asset planning?
Ideally, it's best to get started early, right? When you are getting things going, have everything done the right way is ideal. Now, can everybody accomplish the ideal? No. in terms of what I see in my practice, usually it's around the $1 million to $3 million mark where people will start saying, hey, we've built up assets now, and we want to make sure that we're going to be in the best position to keep those assets in a worst case scenario. So there's no one right answer to that. I've got clients who have 5, 10 plus million, and they're talking to me for the first time as well. But I would say, yeah, once you have something to lose, it's worth your time and effort and expense to put in a better structure to protect it.
So where does insurance play in all of this?
Insurance is a big part of it. So when I talk to clients about goals of asset protection, insurance is one of the, I would call the 3 big layers that we talk to. We want to remove economic incentives for a plaintiff to go after a client aggressively. And we want to create every incentive for them to settle within insurance policy limits if they're liable. So if you do asset protection the right way, clients are able to settle multi-million-dollar lawsuits for pennies on the dollar. And so yes, I tell clients first layer of protection is usually your primary home and auto insurance, right? You got to have the right coverage there. I then recommend the second layer being an umbrella policy, right? Having a good umbrella policy in place. And if you're not familiar with umbrella policies, hopefully most people are, but they usually come in $1 million increments. And they're usually a lot less expensive than the underlying policy themselves. And so those are kind of the first lines of defense for someone to say, okay, we have this issue, we want to get it taken care of, and you've got those policies in place to be able to take care of the liabilities as they pop up. And then I would say the third layer is where I come in to help clients above and beyond those policy limits protect their assets with LLCs, irrevocable trusts, and limited partnerships. So yes, to answer your question, yes, insurance is a very big part of what I counsel clients in doing.
So Logan, still looking at this kind of from 30,000 feet before we spend too much time drilling down on too many specifics. What are key concepts in your eyes that the listener ought to understand and appreciate in understanding why asset planning is important? Yeah,
so when I talk to clients with key concepts, I usually hit on 4 big ones. So first of all, I want to help clients bifurcate risk. That's a legal word that means to divide, separate, or contain, right? So it's the one egg in one basket theory. I don't want the risk of a lawsuit being multiplied across multiple properties or multiple businesses. So I want to help them bifurcate risk. I also want to help them obtain more privacy, right? So certain professions are targets of lawsuits, whether it be doctors or dentists, real estate investors. People assume that you've got deep pockets if they can, look on a public record search and see, hey, there's a bunch of properties in your name out there. So when I'm done with most of my clients, I want them to look broke from a public record standpoint so that people don't assume it's worth their time and effort to go after those businesses or those, pieces of real estate. Third, I also want to add layers between them and their assets to make it more difficult for a potential plaintiff to reach those assets. And the more assets a client has, the more layers they may want to add now or in the future. And that's really great thing about it. You can put together a foundational structure, but as your net worth, as your investments grow, you can add in extra layers very easily. And so those layers are really what adds the true strength to the plan. And then finally, I want to work closely with their financial advisors, CPAs, in terms of the structure that we put together. I want to implement the tax strategy within the asset protection plan. It's not going to do anybody any good if I put together a plan that the CPA, doesn't agree with or says, hey, I would have done it, this other way. So I want to work very closely with them to make sure that anything I'm going to do is going to make their life easier, not only the client, but also the CPA, the tax professional. I want to try and reduce the number of tax returns that they do have, but while making the tax returns that they have much more lean and efficient, and then also trying to reduce their risk of audit in the future. So that team approach to putting together a good plan is really important.
Now, in talking about some of these key concepts, just jumping off on the last one here, Sean and I have talked about this a number of times on the podcast with different folks, but one unavoidable consequence to asset planning, and we'll get into what some of this means, but layering and bifurcating risk and all this stuff, is the inevitable consequences that is it does add a layer of complexity. Maybe it's minor, maybe it's not so minor, and maybe how extensive it is depends on the assets that you have. But how do you determine what level of a complexity maybe to add to some of this? Because, you know, being able to deal with complexity, I think, or added tasks, right? Added tasks to a person changes depending on the person. Some people can't handle any added tasks. Others can handle a boatload and love an Excel spreadsheet and can hit all those. How do you kind of manage on the front end what is enough complexity sufficient that the person can still handle it and maintain it?
Yeah, I think it depends on the person. It depends on their risk profile, and their general concern. Maybe they, are invested in real estate, but maybe they're also in an industry like, doctors, dentists, or other professionals who, are at risk in a personal lawsuit. So it's not a one size fits all when I talk to clients. It's really custom based on their risk profile, what they are willing to spend for a good asset protection plan. And then as well, I would say it depends on, what's going to help them sleep better at night. What I generally see, and in terms of what we provide for clients, is usually about 3 different tiers. 3 million and less for most clients, I'll usually just recommend LLCs. From 3 million to 8 million, you've got now a lot more assets. Well, and we're going to cover this in kind of the top 5 there, but 3 million to 8 million, we'll recommend adding another layer of complexity called a limited partnership that adds a lot more robust protection for the client and their assets. And then 8 million and above, we recommend an extra layer of protection called a bridge trust that allows the client to go offshore. So that's a lot more expensive on that end. But once you have that level of assets, it really puts up a lot of barriers to litigation and can really bring people to the table to get those lawsuits settled. So it's not a one size fits all. It's really, hey, what works for you? What works for your budget? What's going to be good for you now? And then as things change, we can add to it, plug and play in the future.
Now, you mentioned, I think you pretty much answered this question, but we had it as part of it, and I want to delve into it a little bit. But it sounds to me like, just based on the last of your key concept, working with a CPA, that tax considerations are going to be a consideration for purposes of asset planning, because when we monkey with the ownership of our assets or the holding of our assets or what we do with them can impact tax considerations. So it sounds like tax issues are a pretty big part of asset planning. Is that right?
Oh, for sure. Definitely. I think the biggest issues come in the form of, hey, we're trying to take deductions in different ways with active versus passive, investments, right? So if you have an active business, we'll usually, for a lot of my clients, we'll kind of have 2 sides of the ledger, if you will, right? We'll have an active business side where you can make, S corp elections with holding companies, so that clients can save money on self-employment taxes and whatnot. And so I leave all those choices and decisions, how and where and when, up to the CPA. But in terms of those active businesses, the S corp election for a lot of those clients is very common. And so we'll have that on one side of the ledger. On the other side of the ledger, more of, let's say, the passive real estate investment or stock accounts, other types of investments that clients have. We want to structure it in such a way where we're allowing for the best capability of the CPA to take, deductions for, as you mentioned earlier, the what did you mention earlier? The I'm blanking my mind here. Depreciation. Yeah. Depreciation deductions on real estate investment. And so having real estate owned by an S corp usually does not turn out well. So like I said, we'd have the passive investments more on the passive side with the real estate and keep the active on the other side. So yes, that's a very big component of planning. You got to make sure that your attorney and your CPA are having that discussion.
Now, one other area that you identified in your key concept is this issue of obtaining privacy. So I want to explore that a little bit, only to point out that different lawyers seem to approach this question of privacy differently. There are those that seem to think it's, very important and it should be achieved. And obviously, I think where there's a consensus among lawyers is if you want to achieve it, you probably need a lawyer to do it, because if you do it on your own, you're gonna mess it up. This is an easy one to mess up. But then there also seems to be a camp of lawyers that approach this from like, look, if you know what you're doing, you're going to find the information. This idea that there is some sort of unlimited privacy, we're not going to be able to find it out. If somebody wants to find that out, they're going to find it out. And they don't seem to place the same kind of capital in that side of approach. Where do you land on that? It sounds like you land privacy is something that ought to be considered, and it's something important to your clients, and you'll work to help achieve that. Yeah. Is that kind of where you go?
I would definitely agree with that. Yes, I'm a big fan of privacy. And let me kind of take one step back from that and help most people understand the reason why. So the example is, all right, you're in a car accident, right? And you hit the driver, the car in front of you, and the driver, Dr. Jones, doesn't make it. Now, Dr. Jones is coming, or not Dr. Jones, Mrs. Jones, the widow, is now coming after you for a $10 million wrongful death lawsuit. What's going to mechanically play out in that type of situation? Well, the underlying insurance policy, right? You got to have a good home and auto insurance policy, is going to say, bad news, Logan, you're liable for Dr. Jones' death, and damages are going to exceed, the minimum coverage. If we pay out these limits, we're going to wish you good luck, and they can come after you individually. So that's why it's important to have the umbrella policy, because now we're increasing those limits. But even there with the umbrella policy, right, if they go through a lawsuit or they're looking to file that lawsuit, when they do, they're going to run reports on businesses and real estate before they actually file the lawsuit, right? Because when attorneys go, looking to represent somebody and file the lawsuit, they're going to ask about liability. They're going to ask about damages, right? If it's just a fender bender, nobody's going to come after you aggressively. But like I said, if it's a serious injury, damages, death, they're much more excited to sue. But the goal is never just to sue you. They actually want to collect from you. So that collectability analysis is really important to most plaintiff attorneys. And so in their eyes, low-hanging fruit are things like bank accounts, brokerage accounts, wages, and personal property. With, let's say, once someone has a judgment against you, they need more like, 30 days and $500 in attorney's fees to be able to attach those assets taken away from you. Real estate is a little bit higher up the tree, right? You need more like, I don't know, $5,000 to $10,000 and $5,000 to $10,000 in attorney's fees to be able to take those assets away. And it also takes a little bit longer, probably more like 3 to 6 months. But when they're looking to, file that lawsuit, they're going to run those reports on real estate and businesses. And if your name pops up as an owner of all these pieces of real estate or all these LLCs that own real estate or other businesses, they get much more excited to sue you because they think that it's worth collecting on. So yes, to answer your question, yes, I'm a big fan of helping my clients obtain privacy by using legal jurisdictions to hold ownership of their assets. So for instance, if I'm here in Arizona, I've got a number of clients here in Arizona. If they've got a rental property, yeah, you're going to have an Arizona LLC. That's usually the best way to do it, to have a local LLC own the property. But in Arizona requires the disclosure of members and managers, right? And so instead of having clients plaster their name all over the LLC and have it be public record. We use jurisdictions like Wyoming to be the holding company of the LLC, right? In Wyoming, when you create an LLC, they don't ask who the members and managers are. And so when somebody looks at, hey, who owns this piece of property? The Arizona LLC, which is owned by the Wyoming LLC. Well, your name is now no longer associated with that. And so it doesn't come up as a hit on that research when somebody's looking to sue you personally. So it's not just a matter of, hey, I own this LLC and I don't care who knows that I own it or own the property. I'm going to have, renters and maybe it's going to be an Airbnb or whatever. And there's going to be a lot of people there. I don't really care. That might be fine. But what about all of the, outside risk? Like I said, the car accidents, or if you had some type of defamation lawsuit that you did in your, professional life. I want to help my clients limit that exposure there, limit the risk of somebody thinking, hey, it's worthwhile to come after Logan because he's got all these assets. And so we accomplish that by putting together the structure of their assets the right way.
So I agree that anonymity is a deterrent, for sure. But I kind of fall in the camp of like, hey, that information is going to come to light at some point, for two reasons. Number one, when I did practice litigation, Andy and I, in fact, have worked on a couple of cases where we ended up with judgments against individuals, and they, had Wyoming LLCs, and we were able to, as part of the post-judgment discovery, obtain, a list of every LLC at Wyoming, at least, assuming they were not committing perjury, we were getting a list of every, Wyoming LLC, getting copies of their operating agreement. We basically were able to figure out their entire, structure. But to your point, that was post-judgment, right?
Right.
The second thing, though, is in the plaintiff's personal injury space, where our firm practices a little bit. Whenever we hit policy limits, we want an affidavit from that driver or the insured, or both, depending on, who was driving the car and who's the policy holder. But we're going to want that before we take policy limits, which would, have questions in there on what LLC, what companies do you own? What assets do those companies own? And, we kind of try to pierce their financial status. So I do think at some point that stuff does come to light, but where I really think it proves useful, and I want you to, kind of maybe expand on this, is, and I think it proves useful in the deterrent standpoint when you're doing your initial research on, do we file, do we not file? We can't figure out their assets, we don't file, type of thing. So I think there's a level of deterrence there. But where I found it to be really useful, and you've hit on this already, which is where you have a profession, but you're also engaged in other activities outside of that profession that could create liability, and you don't want it to impact your professional license. Can you talk a little bit about that and the significance of, keeping your real estate investing, for example, separate from, say, your real estate license or your law license or that type of thing?
Oh, for sure. And that, I would say what you're getting at is more the bifurcation of risk, right? Of, hey, I've got a business, a profession, my license, we're doing a bunch of things. If your business office is owned by the same LLC, the same, company where you're, client facing, yes, you're definitely putting at risk the office, the real estate, the rental income from that property if your business was sued for some type of professional liability. So yeah, that I talk to clients about that all the time, especially the real estate investors. I've got a lot of doctor clients as well who, they own their office, and I say, hey, we need to split up ownership here. So we're not, if you have a patient that's suing you for X, Y, or Z, we're now not putting the equity of the property at risk in that lawsuit. It's more just on you and the professional company. So yeah, that's a big deal.
Yeah. And if you're off engaging in activities, real estate related activities, let's just say you own rental properties, and there's a dispute, there's an injury on the rental properties, if they don't know who owns those rental properties, because they're owned by, say, that the top LLC is the Wyoming LLC, for example, they can't then run around, because that's the thing with professionals. They could run around and file complaints on our licenses, whether or not it's a valid complaint or not. It's still expensive, time consuming, costly to deal with it. But if they don't ever know like who's the professional behind it, then, obviously there's certain disclosure requirements for real estate agents and stuff, in the space, but you're putting that off limits. So I think to your point, I think anonymity and privacy is huge, and is a deterrent, and also can stave off lawsuits and complaints later on. But I also think there's times where could it be discoverable? Yeah, it's not a fail safe, and I think it's important for people to understand like this isn't like a perfect science.
No, yeah, I would definitely agree with that. Right, as you said, if once a plaintiff has judgment, yes, there are those interrogatories, and the information is going to come out. But to your point, yes, the tenant on the property that you own can't now go after your law license or after your other professional license. But if you also set up those structures the right way, it's much harder for a plaintiff's attorney to actually try or be able to pierce the corporate veil, if you will, and come after you personally through those entities. So most people know that, hey, I need an LLC for my company, for my business, for my rental property. But above and beyond that, there's not a ton of education about how can we better set it up so that we've got more protection than the average person. So yeah, definitely agree with you there.
So Logan, we're going to jump into the 5 asset planning strategies that we recommend people be thinking about going into. But before we do that, we're for the listeners that's thinking, okay, well, this is just lawyers that want to gin up work here. Why can't somebody? Why is this something they need to think about doing now and going into 2025? Why can't I just wait until the stuff hits the fan, so to speak, and then decide to do this after the fact? Do I have any limitations in doing that? Why do I need to be thinking about it now?
Yeah, that's kind of like saying, hey, Andy, my house is on fire. Will you sell me fire insurance to protect my house? Right? That it doesn't work like that. Nobody's going to sell you that insurance policy. Same with asset protection. You've got to have that protection in place before the stuff hits the fan, so that you are in a position to be able to protect yourself. So yeah, most of my clients, I was actually talking to one the other day. He has an Airbnb, and somebody slipped down the stairs, and now they're coming after him. And he said, hey, I want to get all my ducks in a row. And I told him, I'm sorry, I can't really help you. Right. So if you haven't done it up front, it's impossible. If you try and do it after the fact, it's called a fraudulent conveyance, right? The judges and the courts don't like that. They don't want you hiding assets from your lawful creditors. So if you do it up front and early, well, then now you have a structure in place that's going to protect you when that worst case scenario comes along.
All right. So let's get into kind of our top 5. And as we get into these, Logan, I just in talking with you in the key concepts, I can tell that any one of these or all of them may be appropriate, depending on your circumstance, depending on your net worth, depending on a variety of different factors. So as we talk about them, let's get into, the typical client you see that might need to be thinking about utilizing this. But number 1 is a simple one, but a very important one, and that's the LLC, the limited liability company. Logan, talk to us about, why that's important, and generally speaking, what kind of client should be thinking about the LLC?
I would say the vast majority of my clients, 99.9% of them, when they have investments, especially in real estate, are going to use LLCs. So what we want to do is we want to limit the exposure of renting that piece of property, right? If you own that property in your personal name and somebody slips down and falls down the stairs, now they're going to come after the owner. And in addition to the property being at risk, now all of your other personal assets would be at risk in that lawsuit. So instead, if you own that rental property in an LLC, worst case scenario, yes, now they have to sue the LLC, and worst case, they're going to get the assets. of the LLC, that property. But if you have it structured the right way, they won't be able to get at any of your other personal assets. So we're containing that risk within the LLC. Now, as we've talked about earlier, LLCs can afford privacy. I like Wyoming as compared to other jurisdictions for a number of reasons. So first of all, Wyoming offers the privacy, which is great. Secondly, LLC law was actually created in Wyoming, so it's very protective of business owners. Number three has to do with the cost of maintenance, right? So most people have heard of other jurisdictions like Nevada or Delaware where you can get privacy with a holding company. But just to maintain the entity in those states, you're going to be spending anywhere from $500 to $1,000 a year. Okay. So my clients pay about $200 a year just to maintain their entity. So it's a lot easier on the bottom line to have that protection in place. And so, yes, having those LLCs are really the foundation of a good asset protection plan.
Talk to me on Wyoming LLCs, the importance of an operating agreement. Here in Arizona, we have statutes that say, hey, look, if you don't have an operating agreement, that's okay. Our statutes will step in and act as your operating agreement. Is Wyoming the same, or do you need an operating agreement for Wyoming?
Oh, yes, definitely. You want an operating agreement wherever you are. So what is an operating agreement? An operating agreement determines the rules for the members, managers, and creditors of an entity. And without them, you rely on state statute. Depending on where you live, that might be good, that might be bad. So the reason why I recommend having a good operating agreement as opposed to one you can find online or, oh, my buddy has one and I'll just copy and paste his, is that it's kind of like buying a car. Each different car will give you different amenities and different capabilities. My buddy from law school, John Scaveland, has done a lot of litigation over the past decade as well. And the operating agreements that we've put together have been developed after we've seen a lot of people sued. And as you mentioned, once plaintiffs get a judgment, they now come after not only the assets of the LLC, but try and pierce the corporate veil, right? They try and come after the owners individually. And we've also seen in different jurisdictions where judges will allow a plaintiff to become a partner with you on the LLC, right? And that's how they're going to be compensated. So what we've developed in our operating agreements are a number of what I call poison pills that plaintiff would have to swallow if they want to come after, my client. So things like who's going to be in control and does the client have to make distributions or not? I'm going to tell them, no, you don't have to make distributions to anybody. And hey, guess what? Can I, if I'm not going to give them the rental income from the LLC, now we've got all these taxes. Guess what you can do? You can distribute to that plaintiff the phantom income. And so they have to pay your income taxes. So if the LLC is structured the right way, when that plaintiff is coming after the LLC, the plaintiff's attorney may hopefully say, and that's our goal is, hey, I don't want to touch that LLC with a 10-foot pole because it's going to be a very poor result for the client. So you don't get that same type of protection when you rely on state statute for those default rules.
All right, so the limited liability company is number one. Let's move to number two, and I know we'll float back and forth between these. But number two you have is the partnership. Why do we care about the partnership? I know it's very similar to an LLC, though it's not a formalized entity like the LLC. Why do we care about that? In what ways and when do we care about that as opposed to the LLC?
And so let me, and if I wasn't as clear on this, what I sent over to you, that's my mistake. So when I say a partnership, I'm talking about an LLC taxed as a partnership as opposed to just a single member entity. And here's what I mean by that. So yes, as you mentioned, partnerships can be very informal, and no, they're not very protective, right? You want to stay away from just a standard partnership. So it would be an LLC taxed as partnership. Why do I say that? Well, as I mentioned, there's a lot of case law out there where after plaintiffs have been successful in the lawsuit, they convince a judge that it's in interest of fairness and justice to set aside that LLC. So what we'll do is we'll often have clients who want to get more protection with their standard LLC, and so we'll create a partnership. That's sometimes difficult in community property states like Arizona. So a community property state treats a married couple as one single entity, right? So if you and your spouse own the holding company, the Wyoming holding company, in your personal name, and you're sued here in Arizona, well, it may be that the judge is not going to treat that as a partnership. So what we'll do is we'll have clients create irrevocable trusts for the benefit of their kids or, nieces, nephews, whoever they plan on leaving their assets to. We'll name those beneficiaries of that gift trust, and the gift trust will own a percentage of the LLC, so that in that same scenario, if the plaintiff is trying to convince a judge to set aside the LLC, the judge is going to say, no, we've got this irrevocable gift trust over here. We see these kids as the beneficiaries. We want to protect their minority interest holder rights. And so no, plaintiff, we're not going to set aside the LLC. So from that perspective, a multi-member LLC or partnership is much more protective than a single member entity.
I see. Good stuff, folks. This is high level. This is not for the faint of heart. This is why you need a lawyer. All right, number 3. And I'm just moving through these so we can get through it in the amount of time. So if there's something you miss, you want to hit on and go back, feel free. But number 3, you have limited partnerships. Talk to us about LPs.
So I like limited partnerships for a number of reasons, compared to a standard LLC, even a partnership LLC, for this reason. So LLCs come in all different shapes, sizes, flavors, jurisdictions, taxation, and there's case law all over the place where those have been set aside for one reason or another, and clients have been able to pierce the corporate veil. Such baggage of the LLC baggage does not apply to limited partnerships. There's never been a case where a limited partner has ever been held liable for the debts of the limited partnership, at least here in Arizona. I can't speak to all the other jurisdictions. So I do asset protection planning nationwide for clients, and even for somebody in Texas or Florida, we'll put together an Arizona limited partnership for them, because now they own, the vast majority, 98% or more of their assets below that as a limited partner, and limited partners have no liability for the debts of the limited partnership. There is a general partner that needs to be involved. The general partner has to be disclosed from a public record standpoint. So that's why we'll still use, let's say, the Wyoming LLC as the general partner, because we're carrying the liability there, also to maintain that privacy. But from that perspective, adding, yes, another complex layer to the structure can add a lot more protection from that, case law standpoint. So that's the reason why we like limited partnerships.
What's the typical client you see fall into kind of that bucket where you really start recommending the limited partnership?
Yeah, in terms of assets owned by the limited partnership, it's usually they're starting at about the $3 to $4 million mark. We'll recommend the limited partnerships because it makes sense. It's a more expensive structure for us to put together and for them to maintain and do the right way. But yeah, that's generally where I see it.
I see. All right, number 4, gift trust / qualified personal residence trust. Break that down for us.
So I mentioned the gift trust earlier, right? So that allows clients to create a partnership without actually having to give away control or ownership of their holding company to somebody else. So that's where we get the gift trust involved. Qualified personal residence trusts come into play when you have a lot of equity in your home. So I see a lot of clients these days with tremendous equity, since about 2020, especially here in Arizona. A lot of the real estate has increased quite a lot. And in Arizona, and each state has what we call a homestead exemption. And depending on the state, you may have more or less protection than another state. So in Arizona, we have a $400,000 homestead exemption. And what that means is this: let's say you've got $1 million house, it's paid off. You hit somebody on the freeway and now they're coming after you. If they go through insurance policy limits, they can come in and foreclose on your house. They write you a check for $400,000 and then they get to pocket the rest. So how can you protect that equity in your home? Well, there's a number of different options. You could go get a second mortgage on your home and actually pull out the equity. A lot of clients don't like that idea with interest rates these days. So what we'll have clients do is we'll have them create a qualified personal residence trust. So these qualified personal residence trusts were mostly created with estate tax planning in mind. It's a way for you to freeze the overall value that you're gifting to the next generation. so that if you say, oh, my house is worth 500,000 now, and over the next 20 years, we think it's going to grow to $1 million, $2 million bucks. If you put that asset into the qualified personal residence trust the right way, well, now you're freezing the value at 500,000 so that you could pass all 2 million on to your kids at your passing. And so back when the estate tax exemption amount used to be a lot lower, those were a lot more frequent. So the byproduct of that, though, is that if you have your home in this irrevocable qualified personal residence trust, you now no longer own it. And if you're ever sued personally, you can say, oh, well, we don't own our home. It's owned by this irrevocable trust. We're just beneficiaries of that. And so therefore, the equity in the home is not at risk in those situations. So like I said, depending on where you live, you might have more or less exemption than the 400,000. I have a client in Pennsylvania. They have 0 homestead exemption there, which is unfortunate. I also have clients in Texas and Florida. They have unlimited homestead exemptions there. That's maybe the reason why O.J. Simpson went and bought his house in Florida, so that the Goldmans couldn't collect on the equity in his home there in Florida. So depending on the state where you live, you might have more or less exemption than that. But a qualified personal residence trust can protect all of it for you.
Very cool. All right, number 5, last but certainly not least, the bridge trust or slash BDITs. Break that down for us.
Okay, so during the last podcast that we talked about BDITs, beneficiary defective inheritance trusts. And for anybody interested in estate tax planning, I would say go take a look at that podcast, because we discussed it in detail and what it can do for clients with estate tax issues. But the BDIT also provides a lot of asset protection. So for clients in the 8 million plus category, we'll recommend that if they have, estate tax exposure there, because it provides a lot of asset protection as well. For clients who are looking mainly for the asset protection component and are really wanting to avoid a future lawsuit, a bridge trust comes in very handy. So what a bridge trust is it's for tax purposes, it's a grantor trust. It's an irrevocable grantor trust. The clients are in control of it, let's say, while the waters are calm. Okay. So they control assets, can invest them, use them however they choose. But if there is a lawsuit, what happens is the client is removed as the trustee, and now we have a foreign trustee who steps into their shoes. And so if somebody wants to sue them, they can no longer sue them here in the US. They have to go sue them in the Cook Islands. And the way the law is written in the Cook Islands is, well, one, first of all, to sue someone in the Cook Islands is going to be expensive. 2, the statute of limitations is really short. The burden of proof is quite a bit higher. And even if the plaintiff was successful in all of that, the laws are written there in such a way where the trustee can say, guess what? Go pound sand, because I'm not going to give you any money, right? So what we're doing with the bridge trust is we're really putting up a lot of barriers to litigation, so that the clients can say, yeah, you want to sue me? Yeah, great. You're going to have to sue me over there, and you're going to have to go through all these hoops. It might be just easier for you to come to the table and let's get this settled. And so it provides a lot of robust protection there, and an extra layer of robust protection for clients to really sleep better at night, have that peace of mind knowing, hey, worst case scenario, even if I have the worst lawsuit ever, I've got a plan in place that's going to protect me. So that type of planning is a lot more expensive than the average type of plan. You're looking at about $23,000 just to put the trust in place, plus a $3,000 retainer per year to keep that trustee on deck for you. But for the right client in the right situation, it can make a lot of sense.
Yeah, really, really good information. I what I come away with on this, Sean and I always joke in real estate that the crutch that everybody uses in real estate's the quick claim deed, right? Everybody just is like, well, I can go use that. That'll solve every single problem in real estate for me. And of course it doesn't. It seems to me in asset planning, the crutch is the LLC. They think the LLC is going to fix everything and be the answer to everything because it's so easy to file. It doesn't cost a lot. And it's certainly a very effective device. We certainly use them as attorneys. But if there's one thing that the listener should come away with, is the LLC is not the one size fits all, that asset planning is pretty complex. And there's a lot that a good asset planning attorney can do to protect your assets beyond just forming a quick LLC.
Yep, definitely agree with you there. Yeah, setting it up the right way is really worth the time and expense. And yeah, definitely happy to talk with any of your clients or anybody listening who wants to learn more about their options or get a specific plan custom tailored to their situation.
All right. Well, this has been great information, Logan. Why don't you tell our listeners how they can find and connect with you?
So on the estate planning, estate tax planning side, it's Woodruff Law Firm, WLFAZ.com. On the asset protection side, that's Scabland PLLC, and it's Scabland.com. And yeah, happy to have a conversation with anybody looking to learn more.
All right. Really good information, Logan. We really appreciate you taking the time to be with us. Let's do it again soon.
Hey, thanks for having me. It's been a pleasure.
All right. With that, everybody, that is our show. Make sure to join us this afternoon for the Creative Finance Collective. And we'll see you after Christmas.
Have a good day, everyone.